Thank you very much. I'm here to tell you about an exciting new area of research and enforcement in the antitrust community in the United States. Before I begin, I want to thank the UBS and the organizers for inviting me and giving me this opportunity to tell you about this area of research. And I also need to say that the remarks I'm making today reflect my personal views. They do not necessarily reflect the views of the United States Department of Justice or the US government, for whom I'm currently working. Okay, so let me start with a case that many of you might have heard of. It took place back in 2010. And I apologize for my artistic rendering of the structure of the transaction here. There was an agreement among a number of superstar firms, Apple, Google, Pixar, Adobe, and a few other Silicon Valley giants. And so what I have there is a picture of the logos of the firms, and underneath a bunch of stick figures. And those stick figures represent employees of those firms, and specifically their software engineers. There was a competitive market for these software engineers. These firms would try to recruit or poach the workers, the software engineers of their competitors. And so the CEOs of these companies agreed to stop doing that. And on the slide, you can see an email thread between Steve Jobs, the head of Apple, and Eric Schmidt, the head of Google. Steve says to Eric in the lower part of the slide, "I'm told that Google's new cell phone software group is relentlessly recruiting in our iPod group. If this is indeed true, can you put a stop to it? Thanks, Steve." And Schmidt replies, "I'm sorry to hear this. We have a policy of no recruiting of Apple employees. I will investigate immediately!" Eric. Okay, so this was evidence that the Justice Department gathered, and the Justice Department sued these Silicon Valley firms for entering into a collusive arrangement. Now, the government, by the way, they settled with the government and subsequently were sued by the workers themselves, and they settled with the workers as well for, I think, roughly $500 million. So just a few points about this. First of all, this is just a straightforward collusion. It's a conspiracy among competing firms to set prices, in this case, the price of labor. And unlike an ordinary product market side conspiracy, the firms suppress the price rather than increase the price, but obviously, since labor is an input, that benefited the firms. Second point about this is that today, this type of behavior would be criminally prosecuted. It would have been criminally prosecuted then if this had been on the output side. In the United States, as I'm sure you know, there are criminal violations for certain types of antitrust, criminal penalties for certain types of antitrust violations. A conspiracy to set prices is one such type of violation. The government did not prosecute Steve Jobs. It did not put Eric Schmidt in jail, even though they presumably broke criminal law. The third point about this is that this was a kind of a surprise. The reputations of these firms were maybe a little bit better in those days than they are today. Not as many people are accusing them of misbehavior. And I think people might have thought that this was maybe an honest mistake. I'm not sure. But of course, these firms have enormous legal staffs, and it wouldn't have required much for the executives to talk to their lawyers, who presumably would have told them that they shouldn't do this. So what was going on here? The government was quite concerned about this case and went on to issue some guidelines warning firms that henceforth, if you do engage in this type of conspiracy to suppress wages, we will criminally prosecute. And in the last several years, the Justice Department has brought about a half a dozen criminal cases against firms for entering into no-poaching agreements or wage fixing agreements. So having given some notice, the government now feels free to bring these types of cases. Now, maybe nothing more would have happened, but in the last few years, there's been just a huge outpouring of research on labor markets, and in particular, the problem of labor monopsony. Now, you all know what monopoly means. It means that there's a single seller selling some good or service to multiple buyers. So, for example, in the United States, there used to be an aluminum monopoly. There was just one big aluminum company, and there were lots of customers who would buy the aluminum at a markup. Monopsony is just the same thing as monopoly, but directed toward inputs rather than outputs. And labor monopsony occurs when there's just a single employer in a market for a certain job type. So, for example, and I'll give more examples as we go through these slides, imagine a rural area in Europe or in the United States. There is one maybe big company. Maybe it's a prison, or maybe, well, I assume you don't have private prisons here, but in the US we have private prisons. Or it could be a chicken processing plant or a warehouse. And if there's only one employer in that area and various people with the skills necessary for that job live within a commuting distance, that employer is called a monopsonist. And in many rural areas and thinly populated areas, there might be a small number of employers. There might be 2 employers or 5 or 10. There might be, for example, a hospital, but no other medical care facility within a certain region. And in that setting, we say that there's labor market concentration, which is very much analogous to product market concentration. So as data became available, starting around 2017, a number of articles were written which were published just a couple years ago. And what these articles found consistently was very high levels of labor market concentration in the United States. And I'm just going to ask you to look at the map of the United States on the left. You can ignore the one on the right, which just reflects similar results using a different data set. So the map on the left is based on a very simple type of calculation. Azar and his co-authors carved the United States up into what are called commuting zones, which are basically areas you can think of like a town and suburbs where people will commute to work. And within each commuting zone, there would be a number of different labor markets, each corresponding to a different type of job. So maybe, doctor within that area, nurse within that area, warehouse worker within that area, and so forth. And they calculated the number of employers for each job type and then took the average for the commuting zone and came up with a number, HHI. And the bright colors, red and yellow, refer to very high HHI, labor market HHIs. And as you can see, HHIs greater than 7,200, meaning a very high level of concentration, prevailed in 25% of labor markets across the country. And HHI above 2,500, also very concentrated, prevailed in 60% of labor markets across the country. So this was a big surprise. If you talk to economists, maybe until recently, and you ask them whether there's labor market competition, they'll say, of course. You go downtown into Zurich, and if you have certain skills, there are lots of employers that will compete for your skills. And if you're working at one company and you don't like it, you can just move to the company across the street or down the street or maybe at the edge of town. But it turns out that that's just ignoring, geographically most of the country. So in the United States, most of the country consists of either rural areas, small towns, suburbs. And while there are not as many people in those areas as there are in urban centers, there are quite a lot, tens of millions of people. And those people are in very concentrated labor markets. And where labor markets are concentrated, one would assume, based on economic theory, that wages would be suppressed below the competitive rate. Okay, so just as economists generally believe that in a concentrated product market, prices will be elevated because the sellers will either tacitly or explicitly collude with each other, or because basically they don't face much competition. Similarly, the logic for labor markets is that if there are only a few employers in a particular area, they won't compete very hard for their workers, as a result of which the wages will be suppressed below the competitive rate. That's what these articles find. In the more concentrated labor markets, holding everything else equal, wages are lower. Now, these papers are supplemented by a number of papers that look more specifically at this problem. 3 papers look at mergers of employers. So imagine a situation like this. Again, we're in a rural area or maybe an area near a small town. There are 2 chicken processing companies that compete for people. Working in a chicken processing plant does not require sort of tremendous skills, but it does require skills of some sort, and as well as endurance and stamina. And currently, the 2 firms are competing for workers. So if you're working in one plant and working conditions get worse or you don't get a raise, you can threaten to go to the other plant, or in fact actually go to the other plant to get better compensation. Now one day the 2 firms merge. If they merge and now the plants are both owned by one firm, there's no more competition for these workers. And so these 3 papers show that in that type of setting, as one would expect under like standard economic theory, wages they don't go down, they go up less rapidly when mergers occur in concentrated markets. Of these papers, I believe the one that's the most carefully done by Prager and Schmidt focuses on hospital mergers. It looks at mergers of hospitals in the United States in areas where there are not that many hospitals, relatively concentrated markets. They find that when hospitals merge, wage growth goes down for skilled healthcare workers, the people who have limited options, but wages do not go down for cafeteria workers, security guards, and other people that can find jobs at other types of firms, which is exactly what you would expect based on theory. This is from the Arnold paper. It's just a kind of a simple way to visualize what he found. Years relative to the merger, for the years going up to the merger, to take this example, let's say nurses at a hospital, they'd be making a certain amount of money, and then subsequent to the merger, their wages, the wage growth generally declines. Okay. Third cluster of papers deal more directly with collusion, and this is like the Silicon Valley example I gave before, where different firms or people enter into agreements that could have anti-competitive effects on labor markets. So first of all, non-competes. A non-compete is an agreement in an employment contract under which the worker agrees that after he or she completes employment, the worker is not allowed to work for a competitor of the current employer. So for example, if a doctor enters into a non-compete with the hospital that the doctor works for, the doctor would not be allowed to go and work for a competing hospital, usually within a certain distance, within 100 miles or something like that, and usually for a period of time, like 6 months or a year. So non-competes are regulated by the common law in the United States. The courts will enforce them if they're reasonable. But what people hadn't understood until recently is that non-competes are incredibly common. The tradition with non-competes was that they would be used by CEOs, highly skilled people, people with access to proprietary information. But surveys conducted by various academics discovered that somewhere from 20 to as much as 30% of employees in the United States, or 40% of employees in the United States, are subject to non-competes at one time or another. They're just used all the time, including, for example, for very low-skill workers. So there's a famous case in the United States from a few years ago involving a sandwich chain called Jimmy John's. Jimmy John's employed people who they called their sandwich artists, who put together the sandwiches for people to buy. Jimmy John's had inserted into the employment contracts a non-compete clause which said that after you leave Jimmy John's, you're not allowed to work for another sandwich-making establishment within, I don't remember, something like 6 miles of any Jimmy John's establishment in the United States. And because there were thousands of Jimmy John's establishments scattered over the country, this ruled out most of the country. This was so outrageous that a scandal ensued when some journalists discovered what was going on, and states moved in to try to stop Jimmy John's from doing this. But the point is here that while these agreements are technically voluntary agreements between the employer and the employee, if employers impose enough of them on enough workers, that will greatly suppress competition in the labor market, because it means that potential competitors of the employer will not be able to obtain workers. They're all tied up with the incumbent employer. They're very much like exclusionary contracts in other contexts. Another paper by Kruger and Ashenfelter, also very famous and influential, focused on no-poaching agreements within franchise. So it turns out that franchises in the United States have to file their franchise contracts in some states, and that information is publicly available. Kruger and Ashenfelter looked at the 500 biggest franchises in the United States, which include companies like McDonald's and Arby's and Burger King, employing many millions of people. And they discovered that over 50% of those franchisors had no poaching agreements in the franchise contract. And what that meant is that if you work for McDonald's, let's say in downtown Chicago, and you're fired or you quit, you cannot go and work for another McDonald's. You can try, but the owner of the other McDonald's restaurant is contractually obligated not to hire you, because that would be poaching from the first McDonald's. This too led to a great deal of enforcement. A subsequent paper by Meisenbacher and Norlander looked at a much larger set of contracts and found, I'll actually show you this on a slide, that these no-poach agreements remain fairly common. And then a final example, something people haven't talked about very much, but in the United States, and I imagine this may be the case in Europe as well, for a lot of professions, there is a very blatant, at least parallel wage setting. So for lawyers, accountants, investment bankers, people at the same level of seniority are paid the same amount of money in all of the companies, or all of the major companies. And this is true regardless of where people are located. So whether you live in a high-cost place like New York or a low-cost place like Nashville, Tennessee, you'd be paid the same. And now this might well be lawful. There's no law against parallel wage setting, just as there's no law against parallel price setting. But if it does happen, it does, of course, mean that these markets are not competitive, or not very competitive. This just shows the results of this recent paper, which shows the fraction of franchises with no poach clauses and non-compete clauses. So the line at the top shows no poach clauses, and you can see they decline after the Ashenfelter and Kruger paper comes out in 2017, because various state attorneys general begin suing these companies and they remove the no poach clauses, but still about 10% of franchises use them. And as you can see, they often put non-compete clauses in the franchise contracts, and they remain pretty common as well. And then finally, I just want to mention that there's now been, over the last few years, research in European countries as well. This research tends to find similar results, that there are many areas in Europe where labor markets are highly concentrated. Again, don't think of the big cities, think of relatively thinly populated parts of the various countries, and that wages are negatively correlated with the degree of concentration. Okay, so it's probably a similar pattern. There's also been done some work on non-competes. There's a recent paper that found that 16% of private sector employees in Italy were subject to non-competes, and they're common in other countries as well. This is from one of the papers that shows the percentage of concentrated labor markets in various European countries. You can see it's pretty substantial, with some variation across countries. And there's Canada and I think maybe Japan there as well. Okay, so just a few points about theory and policy. I'm not going to go through this graph. I'm sure most of you have seen it. But the simple point I want to make is that if you think there's anything wrong with monopoly or collusion of the sort that is the usual focus of antitrust discussions, that is to say in product markets, then you should think the same thing when this takes place in labor markets in the form of monopsony. So just as a monopolist, right, if you have a single seller, the seller is going to raise prices even though it loses customers because it makes more money from the additional revenue than it loses as a result of people leaving the market. But there's a deadweight loss because some people who value the good in question are unable to afford it, and then prices go up for everybody else as well. For labor markets, it's the same thing. It's just a little bit backwards, but wages are suppressed now by the monopsonist because the employer doesn't have to worry that if wages are low, it's going to lose its workers to competitors. It will lose some workers, but it will gain more from the remaining workers because it's paying them so little. Notice that the workers that it loses are likely to leave the labor market. They might retire early or just become unemployed. That's a loss of output, right? They're no longer there to work and produce goods and services that customers can buy, so prices may well go up as well as wages going down. So there's a deadweight loss in both cases, less output, and then there's harm to consumers in the form of higher prices with monopoly, to workers in the form of lower wages in the case of monopsony. It's exactly parallel, okay? Which is why, you know, in the United States and Europe, I believe as well, monopsony or collusion in input markets is a violation of antitrust law, just as collusion in output markets are. What isn't always as clear is that that's true about labor markets as well as other input markets, but I'll return to that point in a moment. This is a graph that you should take with a big grain of salt, but I want to put it up to try to show to you that we're not talking about trivial amounts of money here. This is, you can imagine, maybe an administrative assistant in a small town in the United States. In a perfectly competitive market, according to the data in the Azar paper, this person would make, say, $45,000. In a market where there's only one accountant, that is only one firm that would hire this person, that firm would be able to suppress her wages to $30,000. Okay, so that's a $15,000 difference for a person who makes $45,000 a year, as you move from a perfectly competitive market to a perfectly monopsonized market. So that's a very substantial amount of money. Now, of course, in the real world, you don't have perfectly competitive markets, and you usually don't have perfectly monopsonized markets. But it's still quite reasonable to think that in a small town it could have 2 or 3 accounting firms, and the accountant will be paid substantially below the competitive wage. Okay, just a few things about the law. So I'll talk about American law as I know that, as that's what I know. But there are similarities in European law with some twists and complexities. So there's really no controversy that American law applies to anti-competitive behavior in labor markets. So first of all, take the example of a monopsonist. Imagine there's a single employer in a labor market area. That employer under American law is allowed to suppress wages to exercise its market power. But if it tried to engage in something like tying, it tried to force its workers to also use a company store or something like that, that could be a Section 2 violation because the employer is extending monopsony in one market into another market. Then there's the run-of-the-mill contractual violations, restraints of trade. There's no controversy that a wage-fixing agreement, a no-poach agreement, probably certain types of wage information sharing agreements, and non-competes are all potentially subject to Section 1. These are restraints of trade. If they're horizontal, they're per se illegal. And then finally, mergers and acquisitions. The statute refers to a substantial lessening of competition, period. It doesn't refer to product markets or output markets. So a merger that substantially lessens competition in a labor market would be illegal under Section 7. The puzzle is that there have been very few labor market cases in the United States as a matter of history. And this is a graph that I produced a couple of years ago, so it's a little bit out of date, and I want to explain that to you. But the blue bar basically just shows the number of certain types of cases over the preceding few years, regular product market cases. And the orange bar shows labor market cases. And so the first, I don't know whether you can see it, but the first pair of columns reflect Section 1 cases, restraint of trade cases, very common in the United States, regular, price fixing cases and so forth. There were a handful of labor market cases, these franchise no-poach cases I told you about, and a few wage fixing and information sharing cases. Section 2, that's the monopoly section. Lots of monopoly cases in the United States, although plaintiffs tend to lose. Almost no labor monopsony Section 2 cases. There have been a couple recent ones. You might have heard of the Mickelson versus PGA case. That's the golf tournament case. And the allegation and the complaint is that the PGA has tried to prevent the golfers who compete in its tournaments from going to compete in a competing tournament system set up by another entity. And then finally, there are the Section 7 cases, and there's a long history, of course, of merger evaluation by the two agencies in the United States, Department of Justice and the FTC. Virtually none of them looked at the labor market effects of these mergers. They all look at product market effects. And this should be puzzling, right? So there have been mergers, for example, of chain drugstores. And the product market analysis involves looking at whether in different product markets throughout the country, the reduction of the number of competing drugstores from 3 to 2 or 4 to 3 will result in higher prices. That's what the focus of merger evaluation always was. But it's also quite plausible that if you reduce the number of pharmacies from 3 to 2 or 4 to 3, wages of pharmacists will decline or other people who work in pharmacies. So that has been almost completely ignored until very recently. And just last week, a court ruled in the Penguin Random House Simon & Schuster merger and found in favor of the Justice Department in a case in which the Justice Department alleged that a merger between these two publishing houses would have a negative effect on a labor market, the market for the production of manuscripts that would be published as books. So there's some slowly increasing interest in the U.S. government reflected in the cases, showing that it's now beginning to take monopsony seriously. So this raises an interesting question, which is, well, why now? The U.S. antitrust laws have changed very little over more than 100 years. They're written in very broad language. And the courts have recognized that they apply to labor markets and input markets more generally. For many decades, there's a Supreme Court case from the 1920s that found that the antitrust laws applied to a conspiracy among ship owners to suppress the wages of the sailors who would work on the ships. So one wonders, why we have the gap between the number of product market cases and the number of labor market cases. And there's I think some people think this gap might be attributable to certain facts about the world. For example, that labor markets are competitive, right? So if labor markets are competitive, then you wouldn't expect many antitrust cases. Product markets, by contrast, are sometimes competitive and other times are not competitive. And Dennis Carlton, a very distinguished economist, in his textbook on industrial organization, says this flatly: labor markets are competitive, he says. Okay, although he makes an exception for the market for priests, which makes sense, I suppose. But it turns out that this recent literature suggests, no, they're actually not, it's not that they're never competitive. They often are competitive, but there are lots of labor markets, especially in rural areas and other thinly populated areas, where there are only a few employers. And in those markets, one would expect less competition, and suppressed wages. Another false piece of conventional wisdom is that U.S. antitrust law cares only about the consumer welfare standard. Workers are not consumers, so if they're harmed by anti-competitive behavior, they have no claim. That's just wrong as a matter of the law. As I mentioned, the courts have long recognized antitrust claims by workers. From the 1920s, the case I already told you about, as recently as 2021, when the U.S. Supreme Court decided the Alston case, which involved the NCAA, the college football league. Okay, so whatever the consumer welfare standard means, nobody's really sure. It doesn't block antitrust claims by workers. A third piece of conventional wisdom, which I think is powerful but also wrong, is that people think that actually maybe it's not such a bad thing for employers to suppress wages, because if they suppress wages, that means that their labor costs go down, and that will be passed on to consumers in the form of lower prices. Now, that's wrong as a matter of economics, at least under the traditional model of monopsony. The way that you suppress wages is, or the result of suppressing wages is that some workers are driven out of the market, which means that there'll be less output, which could potentially mean higher prices, but in any event is bad for people because people want to be able to buy things. And also, workers are consumers, right? They're all the same people. So if you allow employers to, firms to simultaneously engage in, to engage in labor market violations, they're hurting the same people who, potentially might be benefited from lower prices. But because you have a deadweight cost, in aggregate, society is injured. So there are other possible explanations for this. It may have to do with the role of unions. In the United States, unions used to be more powerful than they are now. Now they have very little power. About 6%, I think, of the private sector workforce belongs to a union. But if you go back to the 1950s, it was more like 30 or 35%. And these unions not only, effectively represented their workers, but by jacking up wages, they helped people who were not unionized as well, because their employers would be forced to raise wages in order to prevent their workers from switching to a unionized employer. So unions are, ideal in some sense at aggregating labor bargaining power to counter an employer monopsony, and can use that power to push wages toward the competitive rate. But with their decline over time, which probably reflects both political and technological changes in the nature of work, the workers have lost this protection. And this may, and so now there seems to be a reason for having antitrust to protect workers, whereas before maybe it was not necessary because unions could do it on their own. Unions also in the United States have a historical aversion to antitrust law, because when antitrust law was initially enacted, this is under the rubric of unintended consequences, the law was enforced against unions rather than against firms, because unions are cartels of workers, so that seems like a straightforward application of the antitrust law. So unions have never forgiven antitrust law for that and seem to be reluctant to use it. Okay, final point though is that labor markets are different from product markets in a broad sense, in that there are a lot of frictions. So sellers usually don't care about the identity of their buyers. Apple will sell you an iPhone regardless of what you're like or who you are, whether you have a nice personality or a bad personality. Employers, though, do care about the personalities and talents of their workers, and the workers care about the employers and particularly their co-workers. So there's a much more complex kind of matching model that is necessary to describe this relationship than in many product markets, although there are some product markets that are like that. So when you have all of these frictions, including search costs and types of differentiation, antitrust, the power of antitrust to address labor market problems will be somewhat limited. In the United States, our law is organized so that traditionally labor law, which would promote unions, would address the problem of labor monopsony. And then another area of law called employment law, which would kind of regulate contract terms. Minimum wage is an example of that, would try to help workers. But both of those bodies of law have become weaker, suggesting that today antitrust law may be a useful tool for addressing harms caused by labor monopsony. So over the last few years, I'm not going to read through this to you in the interest of time, but various entities in the U.S. government, including the White House, has expressed concerns about labor monopsony. President Biden, early in his term, issued an executive order directing the agencies in the United States to take seriously the problem of lack of competition in labor markets, and he mentioned antitrust law as a tool for doing that. So it may be that in the future, the litigation gap will narrow, that there will be many more cases against employers for harming labor markets. Okay, just a few final thoughts. First of all, superstar firms. So a lot of these superstar firms are firms that have been accused of causing labor market harm. Walmart, for a very long time, people have argued that Walmart, when it builds a superstore in usually a small town, all the other competing businesses go out of business because Walmart charges a lower price for goods, right? It's a superstar, it can do that. It has this amazing logistics which allows it to minimize costs. But people have also found that once these companies are gone, Walmart can exploit its workers. That is, it can not give them raises, give them bad working conditions, and with these other businesses gone, workers are unable to say to Walmart, if you don't treat me better, I'm going to go find a job at another firm. But the superstar firm problem is a real one because Walmart, Amazon, when it opens warehouses, they do hire people who may not otherwise have jobs or who have jobs that are lower paying. So we just have this classic problem where if firms are able to exploit economies of scale, they may just naturally obtain market power, and the result may well be not only higher prices, but lower wages. Now, as you all know, antitrust law is heavily dominated by economics, and I, like many people, think that's a useful frame for thinking about antitrust harms. But I also want to spend just a minute trying to urge some of the economists here to think beyond economics. So one way I've been trying to persuade people to take seriously the use of antitrust law as a tool to deal with labor monopsony is just to point out the similarities between labor-side antitrust and traditional antitrust. The same economic principles apply. You rely on the same kind of data. The law is the same. So you shouldn't object at the thought that antitrust law should be used in labor markets. But there's a sense in which the use of antitrust law in labor markets is more urgent because work is much more important to people than particular types of goods and services. So your average antitrust law is about flat screen televisions or cars or car parts or glasses, or pharmaceuticals are important, housing is important, but there are these things that people consume and it's important to them, but are not really essential to their dignity and well-being. Work, by contrast, is how most of us spend most of our time. Around 40 hours a week. This is not only where you spend most of your time, it's, according to social science work, the source of people's well-being. They want to be not only working, they want work that is meaningful to them, that they want to have good colleagues, they make friends at work, they obtain standing in their community, mental health is tied to work in complex ways. And the philosopher Elizabeth Anderson argued a few years ago, and this is, echoes claims that have been made down the centuries, that employers are like dictators, right? You're free and equal as a citizen of Switzerland or Germany or United States, wherever you're from, but once you enter your workplace, you're subject to the whims of a boss, and that's inconsistent with how people should be treated. Now, all of this is, true or sort of true or has an element of truth to it, and it's another reason for taking seriously the notion that we should be worried about excessive concentration in labor markets. Excessive concentration means not much choice. If you are a worker and you cannot credibly say to your employer, if you don't stop mistreating me, I will leave and go and work for a competitor, then you are vulnerable to that mistreatment. So antitrust law has a role to play to protect here, has a role to play here. Okay, let me conclude. There are very simple implications to the argument I've been making, which is basically just antitrust law or competition law should be applied to labor markets in basically the same way that it's applied to product markets. I'll just give one example, which is the treatment of mergers. The tradition of just looking at the price effect of mergers should be supplemented by a new tradition of looking at the impact of mergers on wages. That is a straightforward thing that can be done using the same sorts of economic tools that are used for evaluating price effects. That's just one example of a broader project, but I think it should suffice for now. So thank you very much for your attention.